Next, we will have Sheriff Gualtieri to present on a pretrial release program that they run in his county. Thank you for being here.
Thank you for having me, Mr. Chairman. Let me see if I can pull this up here. Okay. Good afternoon, Senators. Bob Gualtieri, Pinellas County Sheriff. Many of you know I chair the Legislative Committee for the Florida Sheriff's Association, but I'm not here today in that capacity. I'm here as the Pinellas County Sheriff at the request of Chairman Bracey to present to you about the pretrial programs that we have in Pinellas County. Just to kind of follow the theme, I think, a little bit from what was previously said is that talking about, for a second, about the purpose of bail. It's to make sure that the people who are released show up for court and that they're not a danger to the community. Judges' challenge is to set proper bail that ensures that. And while some bail amounts are proper, given the nature of the charge, given the nature of the defendant's history, etc., the bail amounts are simply too high for the defendant to meet because they can't afford it. To give you an idea, the cost to house an inmate in the Pinellas County Jail is $126 a day. The cost to house an inmate is high. The cost to supervise somebody on electronic monitoring is $4.50 a day. And if you put somebody on CAM or continuous alcohol monitoring, I'll talk more about that in a second, it's $8.40 a day. So the goal is public safety. The goal is compliance with the terms of release. For us, it's effectively managing the jail population and against the backdrop that bail is not and should not be punitive. So in 2014, we had a serious crowding and overcrowding problem in the Pinellas County Jail. About 70% of the 3,000 plus inmates in the county jail were in there on a pretrial release status, meaning they're pending disposition of their case, they weren't sentenced inmates. So, as we know, if someone can be successfully released from jail and they're going to show up and they're not a danger to the community, it's better that they go out, go back to work, support their families, than sit there for months and months and months, or sometimes over a year, waiting for their case to be disposed of. And when people are just sitting in jail because they can't afford the bail, it's not a win. The judges needed more oversight because the bail amounts they were setting, given the facts of the case, the nature of the charges, were not too high because the judges have an obligation to ensure public safety and that somebody's going to comply with the terms and we don't have high failure rates. So I went to the judges and I said, if we give you a confidence factor that these people are not going to reoffend and they're going to show up, by the sheriff's office instituting a sheriff's office run electronic monitoring program and continuous alcohol monitoring program, because one of the things we know about a lot of these offenders, one of the reasons why they offend is because they have substance abuse and alcohol problems, and it's the alcohol that causes them to offend. So we can keep them off the booze, and we can keep them working, and we can keep them in a situation where they'll show up for court outside of the jail, and we can assure you that you won't be on the front page of the Tampa Bay Times because you released the wrong person. Then would you work with us and lower these bond amounts, and we'll provide active electronic monitoring so they can't afford a bond and that they can get out and we can ensure public safety. Now the key to this is active electronic monitoring. And there's a big difference between active electronic monitoring and passive. Active electronic monitoring means that when there's a strap cut, when there's an exclusion zone violation, meaning somebody goes someplace they shouldn't, there's an inclusion zone violation, meaning they leave someplace they shouldn't leave, that somebody's responding out there and holding them accountable for it immediately as opposed to 2, 3, 4, 5 days later, which isn't accountability at all, and that's passive monitoring. Passive monitoring doesn't work. So an example, you've got a defendant that's in jail on a $10,000 bail. Senator Baxley, to kind of answer your question to the previous speaker, a $10,000 bail could be an aggravated battery case. It could be a residential burglary of an occupied dwelling. It could be something along those lines. It might be a low-end robbery bail. Something along those lines would be $10,000. You get into the $5,000 range, you're still talking about burglaries and some aggravated batteries. It depends upon the circumstances, but those are the nature of crimes generally you're talking about in that range. So somebody's sitting in jail and they got a $10,000 bail, they can't make it, and they can't afford the 10% to a bondsman. We get the judge to reduce it to $5,000 because they can't come up with the $500. They can't come up with the collateral. We put them on electronic monitoring and/or CAM supervised by the sheriff's office, which means they don't leave their residence between 10 and 6. They can go to work. They don't go within 500 feet of the victim's home, and they don't consume alcohol. So that's the framework that we established. We began this program in October of 2014. Since October of 2014, we have released on supervised bail 1,700 people. We average 200 people a day that are on electronic monitoring and or continuous alcohol monitoring through our supervised bail program. The system allows us to randomly test for alcohol consumption, absorption, and elimination through an AMS and or a SCRAM system. And we can have random sampling, so somebody can be at work and we can randomly test whether they've consumed alcohol. If they're at home, we can do the same thing. There's a variety of systems and that we can ensure these people are not consuming alcohol, which again causes a lot of the problems and why they reoffend. So of the over 1,700 inmates released through our supervised bail program, 52% were released on a combination of CAM and bond, 43% electronic monitoring and bond, and 5% both bond, electronic monitoring, and continuous alcohol monitoring. And when you look at the numbers, they speak for themselves, is that we have 200 people every single day that are out of the Pinellas County Jail in the supervised bail program, and if they were in the jail, it would cost $126 a day, and if you annualize that cost to keep them in jail would be $9.2 million. And these are hard numbers. These are real numbers. To put them on supervised bail with electronic monitoring and or CAM, it's $900 a day for those 200 people, or $328,000. So it's a difference annually of $328,000 or $9.2 million. The average length of time that someone spends on our supervised bond program is 88 days. So again, to do the math with that, if they were in jail for that full 88 days because they couldn't make bail, is that it would cost $11,000 for their stay, and with them out on EM or CAM, is it's $396. And this is where the rubber hits the road, is whether this is successful. And 99.5% of all of these people appeared for court as required. 95% did not commit a new crime while on supervised bond. So the total number of the 1,721 who didn't show up is 8 people. 88 out of the 1,721 had a new arrest. We had some, as it shows in that third bullet there, didn't comply with the terms, but we were able to get them right and get them on the right track. They might have consumed alcohol, maybe they missed curfew, maybe they left home where they shouldn't have, those kinds of things. But we went out and had our heart-to-heart with them, got them on the right track, and they successfully completed it. So the program has an overall full compliance rate of 80%. And it's because the judges make the right decisions, because we use active monitoring, and I also think is because the active monitoring and having sheriff's deputies involved in it matters. And I've seen programs where it is not run that way, and I think that they know that we mean business, and when the sheriff's deputy shows up and says, look, you went someplace you shouldn't, get on the right side of this, is that they generally comply. About 45% of these cases were felonies, 30% misdemeanors, 25% DUIs, which would be a combination of felonies and misdemeanors. This gives you a breakdown of the types of offenses. And that's not a typo in there where it says 5 of them were murder charges.
Sheriff, we have a question.
Yes.
Hi, Sheriff.
Hey, Senator.
This is all things that these are all things that you're describing that are done before there's an adjudication of the case, right?
Correct.
Do you ever find a situation where, because somebody's having to go through the paces of whatever supervision, in other words, they can't consume alcohol and they've shown that they're not, in fact, consuming alcohol, or there's something that you're doing to show that they're performing well, that is then, that data is then utilized almost like a time served, or they're electronic monitoring, so they can only be in certain places at certain times and all. Right. Is it treated when they come back to court, the judge will say, well, you've shown for the last 30, 60, 90 days that you haven't been out past 10, you haven't done all the things you have to do to comply with the supervision, and that becomes wrapped up in a final disposition of the case?
I don't have any data for you on that, and so I guess my answer would be somewhat anecdotal, although it's based upon discussion with the judges, and they certainly do take that into consideration. You know, when somebody complies with the terms of release, that's what we all want them to do. They're charged with something, we want them to show up, we don't want them to reoffend. And that when somebody complies with these terms of release, it is something the courts are looking at as far as the person's overall conduct and in the disposition of the case.
I say that because it almost is like a probation. Is that a fair, I mean, it's not the same because maybe you don't have to do some things that are active that you normally would have to do. You just don't have to not do something. But is that, am I looking at that wrong or?
No, I think it's a fair analogy, and you're not paying restitution because the case hasn't been adjudicated. You're not generally doing some programs, et cetera, but there is a high level of accountability with it, and it's very similar. You know, if you can get through this, you can probably get through probation, and that's a whole other topic that people have challenges in getting through. But our goal is to get them through all of this. So no, I think it's very similar because of how we structure it. And some people, and we have some because, as I'll talk about here, we do use a risk assessment instrument. So our level of supervision on these people varies from individual to individual. Some it may be call in once a week. Some may be you need to show up. And some the deputies may go and visit you at your house. So it depends on the person's conduct and what the level of supervision is that's needed.
On the risk, so you use a risk assessment tool, obviously.
Yes.
Is that tool utilized in the sentencing phase or shared with the prosecutor or the judge when they're deciding what is an appropriate sentence?
No, it's only used by us in the phase to recommend to the court that the person should be a participant in this program. It's shared with the judge who makes that decision, but beyond that, it's not shared.
Should it be? Or do you think that?
No, I have no problem with that. It's not asked for, and it's just not part of the process. But I am a firm believer in risk assessment tools, validated ones that are evidence-based, so that evidence-based decisions can be made. They work, and I'm a supporter of that.
Thank you.
Thank you very much, Mr. Chair. Thank you, Sheriff, for being here. Of the 1,700 that are on have been released prior to adjudication, you said that in instances where they violated, the violation was addressed. Does that mean that they're brought in before a court? What does it mean when you say the violation has been addressed?
Most of the time, it's the deputies addressing it with the individual. If you have somebody, as an example, it could be brought to the court's attention, but most of the time it's not. It's somebody that violates an exclusion zone. They shouldn't be someplace. They went there. They were supposed to be home. They didn't. Again, they violated curfew. It may have been a situation where the person consumed a small amount of alcohol. You know, we're not going to all the time go run to the judge. We want to fix it. We want to get them on the right track. Sometimes it's just a heart-to-heart between the deputy and the defendant and saying, look, you know, you need to get on the right side of this. If you don't fix this, then we are going to take it to the next step. So a lot of times we're just dealing with it ourselves, and it works very well.
Any other questions?
So as far as the offenses are concerned, and I want to just point out to you, of those battery cases, 812 of those, almost 58% of those are domestic batteries. You can see the bond amounts. Of course, the $100,000 bond amounts, those would be the murder cases and the other significant ones. In addition to the supervised bail program in Pinellas County, we run a release on recognizance program, an ROR program, which is different. This is where people are released with no monetary conditions whatsoever. So that's where somebody comes in. We either administratively release them from the booking desk under a bond schedule, or they go to first appearance court. At first appearance court, if they're not released, the judge can refer it to us for an investigation. We will use the risk assessment instrument, and we'll conduct an investigation and then make a recommendation to the judge. So we have, in addition to the 200 people that are on the supervised bond program that we just talked about, we have another 700 that are released every day that are out there on just supervised ROR. We also monitor the jail population, and we self-initiate and go and talk to individuals who are in the jail who we think may be good candidates. So this is without a request from a defense lawyer, without a referral from the court. This is where we are, if you will, policing the inmates in the jail and trying to determine those who may be good candidates. So we self-initiate ROR investigations without a referral and then take it to the judge. So putting it together between the supervised bond program and the ROR program, as I said, there's 900 people a day on some form of supervised release status who would otherwise be in the county jail. Our average daily population today is 3,000 inmates, and I can tell you as of this morning, we have a full house. We have 3,000 inmates, and we had 176 on the floor. So if we have these 900 who are out, what are we doing? And the expense would be astronomical. The cost to house those 900 people would be $113,000 a day or $41 million a year. The cost to run our entire pretrial release program is $2.1 million. It's 27 employees, and so the annual savings is $38.9 million, with 99% of the defendants appearing for court. On the electronic monitoring program for supervised bail, we spend about $500,000 a year to the provider for electronic monitoring. And if the defendant can pay, we ask the defendant to pay. They all can't pay. So it costs us $4.50 a day for electronic monitoring. And if they can pay, they pay about $8 a day. And we generate about $175,000 in revenue. So about 35% do pay. So the $500,000 cost is offset by the $175,000. If you put all this together, the cost of the pretrial services program is $2.1 million. Our net cost for electronic, or what we pay for electronic monitoring, is $400,000 annually for all the programs. So the net cost to run the program is $2.6 million. That includes electronic monitoring costs, 27 people, all the personal services costs with running it. And the savings for spending that $2.6 million, the savings is $39 million, and again with a 99% compliance rate. And I can't tell you what I would do if we had those 900 people that were in the jail. And over a period of time of implementing this over years, we have realized true cost savings. We've eliminated positions, we've closed housing units in the jail, and while we're full today at 3,000, at one point our jail population was pushing 4,000. Our capacity was 4,000. So we've been able to close housing units, reduce personnel, get it to a jail that's manageable. And yeah, we've got a couple hundred on the floor, but we can work through that. But we couldn't survive with these 900 in there. And there's no reason, because they are successfully completing what we're asking them to do with appearing for court, and it's not a danger to the community, with a 99% appearance rate.
Senator Brandis.
Thank you, Mr. Chairman. Thank you, Sheriff. This is a great program. So obviously your other sheriffs have heard about this program and are discussing this with you. Have you heard any hesitancy by other sheriffs to implement this similar type of program? And then what else could we do to provide incentives for them to enhance their programs?
Well, I'm going to tell you, you asked the question. I mean, not everybody agrees with this. That's why I prefaced my remarks what I did. I'm here as Bob Gualtieri, the Pinellas County Sheriff, at the request of the chairman. I'm not here as representing the Florida Sheriff's Association, because I think there are sheriffs who don't agree with all of this. And that's their prerogative. I'm not here to tell anybody what to do in their counties or how to do it. So not everybody is in agreement with it.
Any other questions? Yes, Senator Baxley.
Thank you very much. I was listening for a computation. Sound like there's quite a bit of maintenance of going and calling on people if they're violating, what did you call that, supervised bond?
Yes, sir.
Where is there still a bond? Why are we calling it supervised bond?
Right. So if somebody goes to jail, gets arrested, and they get a $1,000 bond. Bail bondsman shows up, they pay the fee to the bail bondsman, and they go about their way. And they have to show up for court, etc. But to the extent that the bail bondsman asks them to do certain things, or the bail bondsman are supervising them, but that's not like this. The assurance, the theory is, the assurance of having to post this bond is what will compel them not to flee the jurisdiction and will keep them from committing other offenses. There's no supervision on a daily basis. So a lot of people who the courts feel need a higher bond, because we need higher stakes to ensure that they will show up and to ensure that public safety is affected and they won't commit new offenses, they can't make that bond amount. So where this is supervised bond is a combination of the bail bond industry. So it's a partnership, if you will, between the bail bond industry and the sheriff's office, because the bail bond industry will provide that bail bond for the $5,000 bond, the person's provided collateral, and the $500. And we're providing the electronic monitoring and or the continuous alcohol monitoring, and the deputies are keeping an eye on them, making sure that they're doing what they're supposed to do. Otherwise, the bond amount might be $15,000, $20,000, or $30,000 because that's what the court felt. So the judges are willing to pull it down if we're willing to step up and supervise them.
Okay, and as a follow-up, how do you account for the man-hours of cost of providing that supervision? Are those separate people, or are these deputies on patrol that are going to answer a call?
There's 27 people in the unit. Some of them are deputies. It's dedicated resources. We have dedicated personnel that do this.
Thank you.
Thank you, Sheriff. Excellent presentation, excellent program, and we appreciate your expertise on this. And members, I hope that